are you? And where are you going? What do you want?
Hello and welcome to Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time to talk about probate and trust administration, estate planning, and all of the attendant subjects related thereto. And today, I'm very pleased to welcome back my good friend and colleague, Bill Gross. Bill Gross is probably the top real estate agent involved in probate, certainly here in California, perhaps in the entire country. So I have never met any real estate agent who knows more about the probate business than Bill does. And his knowledge extends far beyond just the real estate part of probate. And Bill probably tell us, that some of that will come out as we do our discussion. So Bill, thanks so much for being a guest on Trust and Estates Weekly.
Thanks for having me again. It's always a pleasure to chat with you about real estate and probate, my favorite topics.
Yeah, so it probably sounds a little bit deja vu-ish because Bill does a weekly show that's actually somewhat of the model for this show called Probate Weekly. And I'll plug this a couple of times, but you can see Bill's show on his YouTube channel. And I encourage you to check out Probate Weekly because a lot of great guests and information on that channel as well.
Thanks.
So Bill, first of all, take a minute and talk about, I mean, like me, you've been in a kind of a number of areas in real estate and related fields over the years. What drew you to probate?
You know, it was the first time I really spent some time thinking about what I wanted to do in my career. I was 60 years old. I had spent a good part in residential real estate and mistakenly got involved in management and coaching and recruiting. And I say that because I'm really an entrepreneur at heart, and it's very seductive. I think my generation assumes, management is a more prestigious position than sales. And in reality, in real estate, you have the opportunity to build your own business and have so much more flexibility and, choose the direction you want to go. So at 60, I found myself relaunching, and I could have retired, but very modestly, and didn't really want to. And I really spent some time. I spent literally 30 days exploring, planning, researching, and I was really trying to find the intersection of three things, which was one, what was I good at? And I've always been interested in law. I'm a good learner. I feel like I write well. Those are probably my strengths. Second, I think that I always enjoyed going to court. My father was an attorney. I enjoyed putting on a Brooks Brothers suit and tie and going to Stanley Moss Courthouse, which was only half our way. It was convenient for me to go there. And then third, in my research, I realized there was a gap between what the market was offering clients and what clients needed. And I discovered about 90% of clients love their attorney when they hire them in a probate administration case. And after 90 days, 9% hate them because the mismatch between their expectations and the delivery. And that seemed like an opportunity to kind of fit that gap and help the attorneys be more effective, as well as help the clients navigate through the process. So I started that about 6 years ago. I used to go into court every day. I also went in to see court sales every day because I had the calendar. I could pick them. And so I would see 2 or 3 sales a day, whereas a normal judge might see 1 a week. And within a year, I probably had seen more court-confirmed sales in my county than any judge or attorney or realtor. And so I use that as my launching pad for my expertise in that particular niche.
So I want to talk about the court-related procedures in a moment, but start out, talk more broadly. How is being involved in probate real estate different than being just, why can't I just call it my regular real estate agent?
Right.
Maybe I have an existing relationship, and they helped me, find my house or find me a house or sell me a house.
Right.
Why shouldn't I use them?
Right. Well, again, I think number one is for clients, for petitioners, administrators, executors. I don't think that most attorneys, there might be at the top 1%, but if you take, all the cases they file in LA County, about 90% of them are being filed by an attorney who's done one or less in the last 12 months. So you can't be great at anything if you do 1 year or less. And so the attorneys need somebody, I think, to kind of be the grease in the gears to help the customer through the process. They don't really want to, for the most part, handle the soft skills not related to the law or the administrative work not related to the law. And so, but yet the customer needs help. And so I found the opportunity to fit that need, number one. And then two, where there's objections and confrontation and litigation, a mistake by attorney can be very costly. And I just found so many attorneys did not really know the specific procedures to get homes sold. They had some ideas and they would throw out some, but they didn't have the vendors. They didn't really know the process down well. And, most of them had, paralegals. Well, I'm way better than a paralegal on this one narrow niche of law of selling homes in LA County in particular, or California, with court confirmation. So there was an opportunity to present itself both to service attorneys and to service customers, that by being really hyper-focused, I was able to create value for them. And in any business, I really believe that if you create value for customers, the compensation just kind of flows naturally as a result of that. So that was my focus.
Yeah. So talk to us then about how is the actual process different, right? So if I'm a lawyer, I'm selling my own house, right? I call up my agent, and the agent does whatever. But this is a different process. So talk us through that process so people can understand the steps and the complexity.
Yeah, I mean, I think first, if you're a petitioner, you're getting some free help on the administration side. I'm not just a realtor, but I also can help you in the probate. For an attorney, I feel like I'm really a highly skilled paralegal in this niche, because they know bits and pieces, but my experience is most of them who aren't in this field regularly don't really understand. I'll give you one very common misconception, which is homes that go to sale for confirmation at the court need to be clear of all contingencies. And at that point, anybody bidding on it has to raise the bid by 5% plus $500 and have a cashier's check made out for 10% of that bid. That doesn't mean the initial buyer has to buy it without contingencies and or all cash or with a deposit. The truth is, depending on the property, you can have a normal buyer who puts a VA loan, no money down or 3% down. At some point, though, they clear contingencies and have to be able to close. And that's when you file the petition. And so a lot of estates lose a lot of money because the real estate agent and or attorney don't understand that the process, a court confirmation doesn't dictate the process of the sale. It can influence it. Some properties need a cash buyer, and you need a buyer who can last through that process. But again, there's so many misconceptions, and that's one of them. Another one is, I think that with the change in the court, so much can be done online. And in fact, you can manage the court confirmation process online. I think it's a mistake if you're trying to maximize the price for the estate. Somebody should be there. Somebody should be coaching the bidders on how to bid more, make it easier for them to bid more, because it's easier for them to bid more, they're more likely to bid and make more money for the estate. So again, it's a lot of little details, but I just think in general, this is an area that if an attorney's only going to do 1 or 2 probates a year and 1 out of 10 have court confirmation, they might not do one but for every 10 years. So rather than spend a lot of time and try to learn it at the risk of making mistakes, I feel like I bring in that expertise on the procedures and administration to help them be successful.
Okay, and I mean, how is the paperwork different, for example, right? Because if a sale has to go for court confirmation or may have to go for court confirmation, especially in a state like California, where I know over my career, the contract to sell a home went from, I think it was 2 pages, two letter size pages, to now, I don't even know how large it is now. What is it, about 15, 20 legal size pages, right?
I do it all the time. I don't even know, because we keep adding new forms that go to the So it's like an 18-page form, and then you have all these other addendums, and the addendums keep growing. So I don't know. I think it's like 40, 50 pages by the time we send it out for signature. It's
Yeah.
crazy. Yeah, California is different in that we have, and I think it's a good thing. California Association of Realtors has created an addendum for all listings that are probate, and an addendum for all purchase offers that are probate. I think it's great. I think they've done a great job. As a real estate agent, I feel like it protects me. I feel like it protects my clients as well. Of course, most real estate agents have never read the form. And so, I look at that as my sword or my knife. If I was a warrior, the more effective I am with my tools or my weapons, the more I can defend my client and or attack the opponent if I have to. So we do have these forms. And you use an interesting word, may or may not require court confirmation, because those are the two choices. There is no third will not require court confirmation. That's a mistake. And people make that statement, and that can be dangerous because either it does require court confirmation for some reason. Most commonly, the state only has limited authority, not full authority, and that triggers the requirement. There's other cases as well, but even if it's not required because of that reason, there are times when there's multiple, let's say, heirs, and in order to close the sale without court confirmation, you need a notice of proposed action cleared by all particular parties, and there's a list of who those people are. And if one of them says, hey, I object, I don't want this property to be sold to that buyer for that price, I think you're selling it too low, you're self-dealing, you're whatever the issue, this or that, the only options are either get them to change their mind or go to court to get it confirmed. And so it may not be required up front, and then you discover it is. And I have a case in that case where we thought it didn't, and then due to an objection, it became required. So it's one of those things where you should never say will not be required, because unless you know, you run the risk of really hurting yourself and or your client.
Yeah. So talk to us about then the actual court confirmation process, not just the part where people are in court, but just, you mentioned a notice of proposed action. Talk to us about that process so people
Sure.
again can kind of start to wrap their arms around what it entails.
So on any probate case, at the end of the day, to sell property, you need a title insurance company to insure title, to make the buyer comfortable and the buyer's lender comfortable. So there are times where attorneys will say to me, well, we don't need a notice of proposed action for whatever reason. The administrator's a sole heir is the most common case. Well, that's great if the title company will agree to that. And depending on who they are, they may or they may not. Sometimes you can just change title companies. Sometimes, though, you're stuck for whatever reason with a particular title company, and they want 2 belts and 3 suspenders, and you're stuck with their approval. But even on a more standard case, if you have multiple heirs and one objects, and so there's some strategy involved. When do we want to do the notice of proposed action? Some attorneys want to do it right away and get it done. I feel like once you have the buyer waive contingencies, now you know they're going to close. And it can take 15 days if the other party doesn't respond. After that time period, their lack of response is considered approval. But if you know they're going to approve it, get it signed and get it in the package right away. If you have limited authority, or there's objectors, litigation, or for whatever reason you have to have court confirmation, it's really important. The process begins by publicizing your intention to sell the property, and you can't accept offers before the date in the publication. And so there's 2 parts that are really important. One is the publication has to be the right publication, usually the same one that got publication for the probate approval, because the judge already approved that firm and that geography. And then second, and I like the company, the Daily Commerce, because they know those restrictions. They also will file, they do more than anybody this, they will file it with the court on your behalf, which is a great step to save some time. But in the publication, it'll say, we'll accept offers on or after, whatever, December 18th. Well, common mistake is the contract signed before that. In fact, I have one where the offer was dated before that, but we waited and then signed afterwards, which is the proper procedure. We just had to correct the probate attorney that it was done properly. But it's important that you follow those dates, because you can get all the way to the hearing. And I've seen attorneys say, oh, it didn't really matter. And the judge goes, well, it matters to me. And your petition's denied. So the confirmation is important. And then once you've accepted a sale and then you're ready to go to court, you then file the petition for court confirmation. And I don't think I've ever seen one that didn't get certain corrections from the probate attorney that serves the judge. It's just so complicated, and so many of the boxes are just so counterintuitive that how you answer them is always a question. And so there's a process where you file a petition, then the probate attorney in the notes will identify certain problems, and then the attorney has to then file and reply to the notes, hopefully enough time for them to be reviewed before the hearing date and cleared. If not, you go to the hearing with these notes outstanding, and the judge is already predisposed to continuing or denying your petition. So that process is critical, and that's where I get involved as well. I track all my cases, and I kind of bug the attorneys. I know some don't like me because I'm on them, but I'd much rather that be the case than to let something sit. And I've literally seen so many attorneys say, "Where are probate notes? I don't even know what you're talking about." And yeah, look, I'm glad to help those attorneys. I don't think that's the right way to practice, and my job is to help. So again, I see these cases all the time, and I look at the notes and I try to help assess what can be cleared, what can't be cleared, how we can clear it, and then hopefully go to court and get it done. And then you show up at court, and hopefully the judge approves your petition and then says, does anybody here want to bid more than this buyer by 5% and $500? There's a set formula, the dollar amounts in the petition. And if somebody shows up, you want to check, make sure that the cashier's check is made out to the state. And then the judge just conducts an auction and somebody bids it. And then you have to fill the form out that says that there was bid in open court. Then your attorney has to submit an order for the judge to sign. This is another big misconception, is after confirmation, many attorneys will say, well, I submitted the order before the hearing date, but the LA County system doesn't work that way. They're going to disregard anything before the hearing. You have to resubmit it afterwards. And so I've seen attorneys say, well, I submitted it, 2 months ago. Well, that's a clue something's wrong, because it takes usually, a couple days, a week. But if you haven't submitted it after the court date, then you haven't really submitted it yet. And then once you have the court signed order, you can close escrow at that time.
Okay. Let's take a quick break and we'll come back for more. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, we're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. So we're back here at Trust and Estates Weekly with my guest, Bill Gross, and we're talking about the complications, I guess is the best way to put it, that attach to dealing with real estate that is in a probate and in this particular case is being sold. So Bill, you talked about, okay, so now we have the judge's signed order, we can close escrow. Talk, if you would, for a minute, because it's not as if there's a whole new transaction created by the court confirmation process. And I think that people also might find that aspect confusing. So again, talk us through that so people can understand what's really going on.
Well, if the court confirms the sale, meaning that in your, when you go to court, you have the order and you're saying we sold the house to Joe and Mary for $1 million, and the court agrees and nobody overbids it, then you simply wait for the order and close the escrow as is. However, if somebody else comes in overbid, so imagine a property is being sold for $1 million and somebody else walks in and says, well, I'm willing to pay $1,050,500, 5% plus 500 more. And here's a cashier's check made out the state of whatever for 10% of that. And there's a bid, and then that overbidder wins. Then it's interesting, it is a very interesting process, because by default, there's no contract now other than in court, you've signed this thing that says, it's overbid in court, here's the price, here's the property, and you reference the petition. and the buyer has that. You don't have a California Association of Realtors contract. Now, some estates try to backdoor it and say the winning bid is subject to all the same terms. That may or may not be legitimate or legal. I'm not the attorney or the judge to make that assessment. But absent that, and I'd say 90% of the time, most people don't think about it, the overbidder, the only contract you have is, I'm Joe Smith, I bid this amount, this is the property, signed by the other party and by the judge, and then you take that to escrow and open escrow and close. So that is a whole new transaction in that sense. And I will say that one of the mistakes I've seen listing agents make is insist on a new contract, because in some regards, you might be giving that bidder rights they don't otherwise have, like a final walkthrough, for example, is one that caused a problem. I was representing the buyer, and the buyer wanted to delay the close, and we're in the rights because the new contract the listing agent, I think, unfortunately forced on us, worked to their detriment. And so it's one of those things where you have to think about, do we want to use a contract or not? And who is the escrow provider? Are they truly independent, or are they going to side, with us, or are they going to side with the other party? So on the overbidder, it is really a whole new contract, and it is kind of the Wild West to get it done. For the confirmed buyer, it's the same contract. This is just a step in the process towards closing. Even if they overbid and raise the price, there'll just be an amendment to the new price, and then you close.
Okay, so if the original buyer, in essence, outbids the overbidder, that transaction continues, albeit at the higher price. But if an overbidder wins, now you've got essentially a contractless contract or contractless situation.
Right.
Okay, so how, from the overbidder's perspective, if he subsequently somehow finds a defect with the property, right? What happens in an eventuality like that, right? Because he has no contingencies once the court has confirmed him as the buyer, right? So he has no loan contingency, inspection, nothing. In fact, it would appear he doesn't even get the opportunity to approve, a preliminary title report.
So the legal title is presented, and it says clear. So you're going to get a title policy at the end. But you're right, you don't get a chance to read it and then start complaining about easements and such, because it is as is, and that was as is. That's why smart overbidders get a copy of the prelim before they bid on it. Good listing agents put the prelim in the MLS package or the bid package. So that's important. And I think also, to your point, the overbidder doesn't have any rights other than buying the property as is. And so if the property as is, let's say, is vacant, and then day before the close, somebody's in the property, well, that's not as is anymore. And so that becomes a bone of contention, because what does as is mean? It's a legal term, and I can't really advise my client other than talk to your attorney. I think we either have a problem or we have an opportunity. And in the case of the overbidder, again, some brokerages mistakenly insist on the customer signing a whole new purchase contract. Well, now you went from as is to all these new rights that might be in the contract, and what does that mean, and what does that look like? So it can vary. But if you write the contract improperly, and I've been the beneficiary of that, and the realtor is yelling at me, "No, this is a probate. You don't get those rights." Well, but you just gave me a contract that you signed that gave those rights to my buyer. So, and I'll give you one other example is, the listing agent might assume that we have to use their title and their preferred escrow, and often it's owned by the brokerage. And I would say, no, we didn't agree to that. We agreed to buy the property as is. Now we have to decide where these things and how these things get done, and it becomes a negotiation. So those are things where, again, you can try to control them in the petition. That's debatable. But if you don't do anything, it really is just the Wild West to get things closed.
So what would happen typically if an overbidder at some point changes his mind and decides he doesn't want to buy the property, right? Again, there's no contract. So for example, there's no, liquidated damages like there typically would be in a real estate contract. So what has your experience shown you in terms of, a sort of a recanting overbidder?
the buyer is going to lose his 10% cash deposit at a minimum. And I've seen attorneys pursue and judges approve additional damages if you can prove them. Now, it's hard to prove damages in a real estate transaction, but theoretically, if a property overbid for 1.1, are the damages at the overbid price, or the damages over the original confirmed price? All those are legal questions that the judge would decide and the attorneys would argue. But I've seen the buyer get. You have to remember, you're in court already. This is not like a civil matter where you might wait 6 months, 2 years to get a judge. On a probate, they're in court all the time, and so they can file a petition, they can file an ex parte, and the judge is not sympathetic to a bidder just backing out for no reason. Now, of course, if the buyer is backing out for good reason, like I said, we did this in a case, and it's interesting because the attorney on the other side is one of my better attorneys. I work with her quite a bit. But my buyer, I think, correctly said, "Hey, we're not buying a property with a squatter in it. That wasn't as is." And this isn't a case that they didn't disclose. This is a case that they disclosed. We want this guy in the house until we close escrow. And my buyer said, "Absolutely not. I want to do a walkthrough the day before with nobody there." And so my buyer did run the risk of non-performance and losing. We ended up closing the escrow because we found some way to get the squatter out, or the friend of the seller out. But again, these things are debatable, but overbidder has the risk of losing his money and also potentially other damages.
Okay, so, and again, I'm not looking for your, I'm not looking for you to, opine legally, but let's say somebody a successful overbidder actually agreed to pay a price that was higher than market value. Maybe he agreed to pay $1.5 million, and in reality, the house is only worth 1.4. And so subsequently the estate sells it for 1.4 million. Presumably then you do have, what looks to me like identifiable damages.
Yeah.
Right. And so then potentially the administrator could petition the court for damages against the buyer who didn't perform.
This is why when I'm the listing agent, I want the cashier's check in my hand. I want it made out correctly. And I want to know we can deposit that check. If it's made out to escrow, no, because it's a subtle distinction. But if the overbid money goes into escrow, then to get it back out, the escrow needs both parties to agree. But the process is supposed to be the overbid deposit check is made to the estate. And so theoretically, the day after the close, the estate should deposit the money right away and have the full use of it and leverage that way. And on the flip side, I've had cases where I represent a buyer and we overbid and we had a cashier's check as appropriate. And the attorney would say to me, "Hey, we haven't opened an estate account yet. Do you mind remaking out the check to the title or escrow company?" No problem. I'm glad to check back. No, I'm not going to do anything dishonest, but my buyer has the authority to do what they want to do. I don't represent them the same way an attorney does. I'm the real estate agent. So of course, we'd rather have the money back. And then once it goes into escrow, now if there's a dispute, the escrow needs both parties to agree at some point, or there's litigation. So this is a case where these little subtle differences make a difference. But if it's your transaction, it could be all the difference in the world.
Well, and this is, I think, an important distinction as well, because as you mentioned a few minutes ago, a probate confirmation sale process you're already in court. Mm-hmm. And now if there is a dispute and the money is in escrow, so escrow is going to file an interpleader action, but that's not a probate court action. That's a civil court action. And so now the estate is tied up in the civil court trying to resolve that. And the timeline in the civil court is much, much longer than it is typically in probate court.
I know you and I were involved with one of those. That's the only one in my career I've seen. Almost every other case I've ever seen in these is dealt in probate court, and it moves very quickly because, even if you file a normal civil, I don't know what the calendaring like is now in LA County, but it could be 6 months or 2 years. But the judge is very sympathetic, putting everything on the next calendar. If you have a proposed resolution, now they're not going to do a whole trial, and if the buyer's objecting. But again, in my experience, the judges, it's pretty kind of dry, man. If you didn't close and the 10 days is up and you document it, I've seen many times where the buyers are begging for the money, and the judge says, "You're lucky we don't, assess damages, or maybe we could assess damages and come back with that later." So yeah, I would be very careful to file loss to think I'm gonna get money back by filing a suit against an estate when they're in probate, because they're already in front of judges.
Yeah, yeah. So, what are the let's go back. Maybe I should have asked this earlier, but from the standpoint of marketing the property for sale, and we've been talking about this in the context of a home, but indeed, and correct me if I'm wrong, this process applies to any real estate that's sold by an estate. So what is the marketing process look like, and how is that, or is it different than the marketing process for a property that's being sold just conventional sale or
Well,
conventional
when your approach sale goes to court confirmation, you're going to have to make the claim and back it up that you market the property fully and represent full market value. Your best effort is represented by the price you've accepted, and so it's important to document more so than a standard realtor. Where you listed the property, what kind of views you have, showings. That those kind of activity can be more important, particularly if somebody's objecting to the sale. So there's that. Disclosing this a probate is important to protect your client and yourself legally, with the proper disclosure in the MLS and the proper forms on any offers you accept. And I actually kind of coach the buyer's agents to say, here's the form numbers, and if you have questions, call me. I'm an expert in this area. I don't represent my own buyers, so I can really walk you through this. So it is important to fully market the property. And I think that's another misnomer. People get in this business used to, as realtors, thinking they could double in every deal and they can kind of hide the property. And I'm sure people do that, get away with it, though I scour the records, try to find those opportunities, because if they're getting it on the cheap, then that's a chance for investor to pay a little more and get it. So the marketing should be the same. And then once you've accepted an offer and then petition for the court confirmation, which can be 30, 35 days or more, you're obligated to continue to market the property up until the court date, because now you're looking at a different group of buyers. You're looking at investors, most commonly, or sophisticated buyers who are going to come up with a deposit. But you still need to continue, once you've publicized the sale, to continue to market the property. And if you don't, that is grounds for the sale being continued, and I've seen even denied, when somebody could prove, hey, you didn't show it, you make it available, I called you 10 times. I've seen judges as a result say, well, it clearly wasn't marketed and we're going to decline the petition. So it is important to continue to market the property.
Interesting. And
one difference is oftentimes, because the person who owned the property by definition passed, more often than not, these properties were vacant and or squatters, or had tenants who were kind of sat there and took advantage of the situation in the environment we're in. And so one difference with probate is very often we do have tenants, heirs, squatters, and that does make showing the property different than a standard residential property where you have the seller in the property. One of the areas that I try to focus on is that person an heir? Because if they have money coming to them through the estate and they interfere or hold up the marketing of the property, then the administrator or executor has the possibility, at least, of charging back the expenses or losses to that heir's percentage. And so I often will make, I don't advise people legally, but I do advise them strategically. Hey, let's make sure we talk about this. If they're an heir, make sure they know that if we have to evict them, it costs us $20,000. That's coming out of their side. All those legal fees are their portion, not anybody else's.
Mm-hmm. So, talk about, and we have a situation like this where the estate is insolvent, right? So the heirs stand to get nothing, and now, but nonetheless, they have taken up residence in the property that has to be sold. So talk about a situation like, and by the way, the reason I bring this up is I take it on faith this is not a unique situation. Probably most estates are not insolvent, but there's probably a percentage out there that are. And on the one hand, I can understand I'm an heir. I'm thinking I'm, oh my gosh, my, relative has died. I'm legitimately sad about that. But on the other hand, now I'm going to be inheriting some money, and oh, wait, now I'm not going to be inheriting money because it turns out, the estate is insolvent. And so now I'm mad, or I'm whatever. And so I take up residence and maybe try to, this may be a strong word, but extort money, from the estate that would otherwise go somewhere else. Talk to us about, a complex situation like that, and how you've seen, those kinds of things how you've seen them dealt with.
Well, the problem is if there's no equity in the property, then it can be argued there's no beneficial interest for the state to do anything, right? So it doesn't make sense to spend money, legal fees or otherwise. There are options for short sales for probate. There are options for short sales, particularly with reverse mortgages. But short sales usually require somebody in the property who's cooperative or vacant. When you have a militant occupant, it makes a short sale probably impossible because you just can't meet timelines. There are cases where if there's a little bit of equity, we can sell the property and their investors will buy the property and take over that problem. And I've done more of these in the last year than I have my whole career, where we just say, look, there's a problem tenant and we started eviction and here's where we're at, but we're not going to continue. You're going to get the property with this person in here, and they're investors in certain markets that will pay. And I think overpay. We had a case where I think the buyer came back to me 6 months later, kind of crying, asking me for help. And I said, well, if I could have got the guy out of there, we would have. You bought the property because we couldn't. So this is an area of the practice that's getting more, it's just changed a lot. A few years ago, I had a Rolodex of eviction attorneys and I knew the eviction laws and we moved pretty quickly. But post-COVID and just, working on all the politics of it, given our current political climate here in LA City, LA County, many surrounding cities, the state, there's so many protections for tenants. There's a militant attitude in the eyes of so many occupants that these are very complicated. And you have to make sure you get to the right person to get the right answer. You and I were in a meeting the other day where our staff people were saying, well, we have great eviction attorney we used 5 years ago. And I tried to explain to him, the guy who was great 5 years ago is not great today because it's a whole different business. 5 years ago, it was an eviction mill and paperwork and dates and such. Now, it's almost like you're a mafioso, that you have to kind of get in and talk to people. And number one. Number two, we're probably not going to be successful. And so I'd much rather let the other attorney pick the eviction attorney who's going to fail than for me to try to find somebody who's going to solve the problem that may not be solvable. And that's the problem. In some of these cases, it's just insolvable. So again, and I just closed a property in Hermosa Beach with 2 tenants that I just don't know how they're gonna get them out, but it's not my problem. We sold the property, got a good price with the tenants in there. And I'm doing more and more business like that.
Yeah. Okay. So you know what, let's take another break and we'll come back and talk a little bit more with Bill.
Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching.
So again, this is Trust and Estates Weekly. I'm your host, Kevin Bemmel, and I've been talking to Bill Gross, arguably the most knowledgeable probate real estate specialist in California. Bill, we've worked on projects in other places besides California. Talk a little bit about your experience working outside of this state.
Well, I think Californians tend to do more business in other states and countries because we have to, because our business climate has not been as attractive as some of the markets are growing. And we are a big state, so we happen to have maybe more resources. But yeah, no, we're working on one where we have a buyer, a seller perhaps in Virginia, and a buyer perhaps in Colorado, and they're all different. It is interesting how, just side note, Colorado has only active removal of passive removal contingencies, which means that you buy a property and you have a loan contingency, and if you waste time and that contingency expires, you've lost the right to use it. Whereas in California, you have to affirmatively remove your contingencies. And so these are small subtleties that when you do business in other markets, in probate or just in general real estate, are very different. Another factoid is, to my knowledge, I've asked this question numerous times, there is no other state in the union that has a disclosure for probate, whether listing property or selling it. And I ask, key originator, real estate brokers, I ask key attorneys in other states, what do you do to protect your client? And they all tell me they write something custom. Well, obviously that takes time and money. And then, how thorough are they on that? And it just always, it interests me. We're in a very litigious area in California. It's not as litigious as states. They aren't really worried about it. And when I ask them that, I'm alarmed to not have a probate addendum for a listing or a contract. I'd be like, what am I going to do? And they're like, yeah, I write something up. It's not a big deal. Because I think doing business in Virginia or Colorado or some of these other states we've done business in, Alabama, people are just different there. Here, it's a very, very competitive, adversarial situation. You have to protect yourself. So it is different in other states for sure.
Yeah, I handle a couple of matters in Alabama, and I remember being in court last time I was in court. I mean, it's maybe a couple of years ago, and I was able to attend remotely, fortunately, but my lawyer was there in court, and the court recessed for a few minutes because the other side needed to go out into the hallway and whatever, confer. And so I'm just kind of, standing here in my office, and my lawyer says to the judge, so how are the kids? I didn't see them in church last Sunday. I mean, it's so different here in California than here in California.
It's so different. I part of a couple of masterminds nationally with real estate agents. And so some of these teachers will say, yeah, go to the court and you'll meet the clerk and ask her questions and she'll give you information, and go into the hearings and ask the judge questions. I'm like, are you kidding me? We have armed bailiffs. The clerk is of the filing area is behind bulletproof glass. They're not going to answer any question other than where's your case number? Here's a file. I will say I did go to Orange County once for confirmation, and I was in the audience area of the courtroom. And before we started, the judge was like, hi, everybody. How you guys all doing today? What brings you here? They haven't started yet. What brings you here? Oh, good. Okay, I look forward to that. Okay, well, and oh, great. You're this, you're that. I'm thinking, man, it's a different world in LA County where, you go through the metal detectors, I think, everywhere, but you feel like you're in this intense, process in LA is very different than any other jurisdiction I've done business in.
Yeah. Also in Alabama, I went to file a document with the court clerk, and I had a thing. She opens up. She says, "Oh, you're Lindsay's client. Don't you just love Lindsay?" My lawyer's name on that matter was Lindsay. Actually, I do. And it's like they knew all the lawyers by name, by reputation. It's so wild. I can't imagine a clerk at LA Superior, or for that matter, even Orange County Superior, knowing the lawyers that well. It's just it's a really very different experience.
I will say the top 1%, back pre-COVID, when the attorneys had to go to court way more often, the top 1% definitely got recognition and from the judges and the staff. You can see it, and they earned it. Now they don't go to court nearly as often. It's almost all video. And they have staffs that go instead of them. So, but yeah, there's certainly. Look, I was it with you or another matter? I was there, and the judge recognized me because I always go on all my court sales, whether I'm representing the buyer or the seller. I always go in person because I want to hear what's going on. I want to see the judge. I want to see the body language. And after a while, you get a reputation with, in this case, the judge and other attorneys. So I do think in LA the best you can. You got to do. But we're certainly more anonymous than other jurisdictions.
Yeah. So switching gears a little bit now, and you've talked a little bit about working with attorneys and identifying experienced versus perhaps less experienced attorneys. But talk about some of the things that you do to work more effectively with not perhaps just the attorneys, but the judge. I think we have this idea of judges. They're in their black robes and they're almost robotic in a way, or with without human emotion. That is not, frankly, my experience at all. It was never been my experience, even back when I had a real estate company and I'd be there for a UD or something. So talk about how you the things that you do to work more effectively with lawyers, with other parties to a probate, with the judge. Although maybe it's not working with the judge per se, but sort of dealing with the judge.
Well, as far as judge is concerned, I actually interviewed one of my podcasts. I was really lucky. I try to learn. LA County Bar Association has an annual, I forget the exact term they use for it, but where the probate judges will kind of share their insights from the bar over the year, changes in procedures and kind of their general feeling, what mistakes they see made. Well, that's really valuable. I always watch that and take notes or record it and take detailed notes and share it with some attorneys I work with, because they're telling you what they like and don't like. You might as well pay attention. I always go to court when I'm on a matter as far as a sale or either side. I show up dressed like an attorney. I think there are real estate agents that don't. I think that's a mistake. And I've learned to address the court in a lawyerly manner because they appreciate being addressed that way. And so, there's probably a combination of things. With attorneys, it's different because, boy, they're also different. And you also spend a lot of time with, I'm always looking for who is the person who's really going to do the work. Is it the paralegal or the secretary in the office or the assistant? And because I end up doing more work with them than I do the attorney, to be honest about it. Mm-hmm. But again, just learning how they do business and trying to understand their cadence. I work in realtor time. As a real estate agent, somebody texts me, they expect either immediate response or within the hour, I'll get back to you. And by the end of the day, attorneys are the only business I work with. And I don't mean to disparage the industry because some are very busy, but you'll send them a message and like a week later, they'll call me and say, "Hey, Bill, this is, attorney so-and-so returning your phone call." I'm like, "Who? What?" "Oh yeah, a week ago." Because there's real estate agents, a week ago, I probably closed the deal already. Like it's just a different life. But we have different rhythms and different cadences. And I think the key is to try to understand your client's cadence and rhythm and verbiage and procedures and try to meet them where they are. And so it varies. You're different than other fiduciaries I work with as well. And I appreciate your professional style. And I try my best to, adhere to those rules, where others are much more inconsistent or less professional, less structured, let's say, and try to, work within those framework as well.
Yeah, good. So we're kind of coming up here on time. So any other thoughts you'd like to share that you think will be, beneficial for the viewers?
I think whether you're an attorney or fiduciary or a real estate agent or, even an administrator of an estate, I do think the focus should always be on creating value for your customer. And I think everything else kind of takes care of itself. That's always been my North Star. Even when I couldn't, when I started the podcast, people would say, "Well, how do you get paid on this?" And I said, "I don't even know." But, 400 interviews later with attorneys, I've learned a lot about probate through talking to attorneys and related vendors. And as long as I'm learning and growing and doing what I enjoy, it's worthwhile. So I would just say for anybody in this business, if this is an area that you want to get into, learn how to be more productive and more valuable for your customers, and the value will take care of itself. Don't focus so much on the business format at the beginning. Focus really more on learning something that you can help other people with, and then that opportunity will present itself more often.
Very good. Well, I think that's a good idea to wrap up on. So, Bill, thanks so much for being a guest on my show today. I really appreciate it. I use my show, I think, for the same reason you do, which is to learn more, but also to develop relationships with people. Because in my experience, the better we know each other, the more effectively we can work together. And in the end, our jobs are similar in that we're looking to administrate an estate as effectively as possible, and so communication and mutual understanding go a long way toward making that happen. So.
Yeah. Yeah, and I might add just one more piece. A little overlap always helps too. I think sometimes people are very clear on drawing the line what they don't do, and they expect somebody else does do, and then things fall in the middle. And I always feel like in any, in sports, you want your areas of responsibility to overlap just a little bit, so that if you missed it, I covered it. If I missed it, you covered it, and we should know where those overlaps are, I think.
Absolutely. Well, again, thanks so much for being on the show today. I'll have you hang tight while I do a quick wrap up. So also thank you all very much for viewing the show today. I really appreciate you watching. If you have any questions, comments, criticisms, all of my social media links will be in the show notes when the episode posts on YouTube. Bill's contact information and a link to his show will be there as well. So if you want to talk to Bill, or maybe you have a transaction that you need a real estate agent for, I always give the shameless plug, because my guests are too modest to do so, but you will not find, I can attest to this personally, because Bill and I have worked together many times. You will not find a more skilled, diligent real estate practititioner than Bill Gross, and across the property spectrum, because we've done both residential and commercial transactions. So I unequivocally recommend Bill to you, and his contact information will be in the show notes as well. So that only leaves for me to thank you again very much for joining us today, and signing off as I always do. Marie, darling, you are my belle. Courage at all times, my friends.